kind of medical professional should write ESC notice? Doctor only, nurse, etc.
So remember, the key term is that they are a licensed medical professional. So it can't be a camp counselor. It can't be simply a clergy, right? So sometimes people, well, I'm getting counseling from my place of worship, and they have suggested that I do this. Unfortunately, that's not good enough. For it to apply in the state of Texas, it must be a licensed medical professional. Typically, your doctor, a nurse, psychiatrist. And so if they have a licensed medical practice or a medical license that's registered, then yes, that qualifies. The question when you sometimes get is, well, what if they're licensed outside of the state? Well, you have the right to ask whether they are currently a patient of this particular licensed individual, and they're currently under their care. Unfortunately, that's about as far as you can get. And so if someone from out of state has diagnosed, has treated this person, and they are under their care, that would technically count. And so we can't be Texas focused. In the past, I mentioned you should limit it to people in Texas, but it's probably best to not to vocalize that particular limitation, because it's probably not accurate. In a court of law, a court would likely say, look, they're licensed in their state and they are under their medical care, especially if they're recently from Louisiana or they're recently from California or some other state, and they're here now. It's going to count. It's going to count as long as they can provide a document from a licensed healthcare professional.
Be specified in the letter, and if not, is it proper to ask for the letter to specify?
First, let me address the second part first. You don't have to ask them to produce a better notice. If the notice itself simply doesn't meet the qualification, then it doesn't. If it's imprecise as to what animal or how many animals, that's a fact issue. If it says, for example, an animal, and they've got 4, you've got a fact issue, because only one animal would satisfy that specific definition. And so if there's a defect in their notice, that's held against them, the tenant. So the other is, what if, can it be any animal? It has to be reasonable, right? You can't have an exotic animal. It can't be a tiger, right? You can't have a baby rhinoceros. None of those things would be legal otherwise, right? And so what does your city code say? In fact, in certain jurisdictions, there are certain species that are just not allowed. And so that would make their accommodation unreasonable. So unless that is an issue, you can't decide for them that this is not there, especially if they have the documentation asserting that it is their emotional support animal, and a licensed healthcare professional has established that.
And that no license is required also. So I think, we've spoken that.
So with service animals, again, these are animals that provide a service, and that service could be an emotional service. So there's very little training for emotional support animals, if at all, and none, in accordance with the law, is actually required. You might have an animal that is trained to, for example, detect when someone is having an epileptic seizure. That's a real thing. Or the seeing eye dog. That's a real thing. But you're not going to ask your tenant to have the dog demonstrate that, right? That's not reasonable. If they have documentation from a licensed healthcare provider that establishes this is what this dog does, and it's that kind of situation, don't question it. Don't ask for much more than that. They've met the standard. I think what they're asking is, if they have an emotional support animal, is there some kind of certification? There is not. Is there some kind of training that's required? There is not. It's extremely informal. If a doctor goes as far as saying that their patient requires a specific animal, then that's them meeting that minimum requirement.
And it's holding over. Is landlord required to give references?
The first place you look always is the lease itself. What does the lease say? What are the requirements? If your lease says, dang it, I give references, then sure enough, that landlord has to give a reference. I've yet to see a lease that, certainly not one that I draft, and certainly the ones that I've seen in the past, where a landlord is absolutely obligated to give a reference. So if yours says that, then yes, that is a requirement. Again, not common. So now that we're past the reference issue, let's address the issue of lease termination, because some leases have a hard end date and some have an automatic renewal. If you're familiar with the Texas Realtors lease, it has a section that specifically addresses and says your lease will automatically renew on a month-to-month basis unless one of you sends written notice of termination within the following time frame. And then it goes on in the Texas Realtors lease to describe what that looks like. 30, 60, 90 days, whatever. It's no fewer than 30. But it could be up to a million gajillion. But it can't be fewer than 30. And in the Texas Realtors lease, the second section is the one that trips so many people up, because they don't understand how it works. So in the Texas Realtors lease, the automatic renewal provision says, I can designate how many days of notice, and by far the most common is 30 days. But some people like 45, some people like 60. But whatever you put there, the next segment says when that notice becomes effective. And it gives you two options. And if you don't pick an option, I guarantee you the tenant is going to choose the option that suits them best, because that's what the court says. If you have any ambiguity in your lease, where it could go this way or it could go that way, it's resolved in favor that suits the non-drafting party. That's typically the tenant. So the next portion says it's either A, effective, let's say 30 days from the date of notice, or B, effective no fewer than 30 days, but only effective at the end of the subsequent month. The language is a bit wonky. I've never actually liked the language in the Texas Realtors lease, particularly when you have 45 or 60 days. It becomes confusing and mathematically imprecise. That aside, what does it mean? Well, let's say it were October 15th and someone sent a 30-day notice to vacate. Well, in this scenario, if the checkbox A were selected, then it would be effective on November 15th, exactly 30 days later. Technically 14, but we're not going to get into 31 days in a month. It would be 30 days precisely. Or B, the end of the subsequent month, which is November, it would be that. If your lease is silent, then it's whatever the tenant chooses. Okay? But you got to follow what the lease says. In this case, it doesn't sound like this person received written notice. So what kicks in the Texas Realtors lease and in most leases, the automatic lease renewal. So this is no longer the regular standard lease. It is now lapsed into a month-to-month, and now they have to honor that agreement. If on day one, which is in this case today, November 1st, the tenant refuses to pay rent, guess what I'm going to advise you to do on day 2? Notice to vacate. That tenant owes the entire month because no proper notice of termination was given by either party, at least that's what I presume. No written notice was delivered by either party. And because of that, rent obligation continues, especially if they're still there. And so the full amount of rent is owed, and the parties have to abide by the terms of the lease. Now there's one tricky thing that might be an issue here, and I want to address it because some people are like, oh, wait a minute, I'm a lease ninja. I'm stealthy and I know all the corners and crevices of that Texas Realtors lease. And it says, if you commit holdover, I can charge you 3 times the rent for each day on a daily basis that you're there. Why does holdover not exist in this scenario? It doesn't exist, according to these facts, because nobody terminated. The lease is still going on a month-to-month basis. It's not holdover until someone says 30 days or whatever the lease requires, someone gives written notice, and then the tenant stays beyond that date. That's what holdover is. You can't call it holdover if nobody actually sent a proper notice of termination. The Texas Realtors lease can go on literally forever, right? Unless somebody terminates it. But certainly if the obligation to pay rent exists, you should enforce it, especially for someone who is all of a sudden making up their own rules. If it's clear in the black and white, enforce it just like the black and white says. In this case, I would do it sooner rather than later. Although my normal requirement is if you haven't gotten everything that you're owed in 7 days, issue that notice to vacate. This scenario is a little bit different because it sounds like things are shutting down. It sounds like things are going just right off the rails. As soon as day one has passed, I would issue a notice to vacate and get rid of this person. They sound like trouble. So
this animal, is there appropriate, or could I be getting myself in legal trouble for this?
Again, an emotional support animal is not a pet. It is a medical device. So if you say no pets are allowed, or you say I love pets, the more the merrier, that's a personal choice. And so an individual landlord can allow or can disallow pets, but they're except for a very narrow exclusion, which I'm not going to get into because it's likely just going to confuse you, except for a very narrow exclusion, you can't reject someone with an ESA. You can't reject someone with a CNI dog. It is a federal offense. And so because you want to stay on the right side of the law always, and you don't want to, and I mentioned the exclusion because people are going to wave it in my face and say, well, Ernie, technically the law says, yes, I see what the law says. I've read the law, and it's easy to get it wrong. And the last thing you want is to be hauled into federal court on a technical violation of that exclusion provision. Just comply with the law. Just do it. I've got some great advice as to what to do when you have animals, when you didn't want animals in the first place, but you got to let them. Guess what? Those animals are not allowed to destroy your property. If that's what you're afraid of, the instant there's damage from that animal, you're going in and issuing a notice of default, not for having the animal, for allowing the animal to cause damage. Not only are you issuing that notice of default, you are paying to repair that damage. And then you are immediately billing the tenant for it and saying, you're going to pay this, and I'm going to give you a reasonable amount of time to pay it. And when they don't, move forward with eviction. That is a strict violation of the property. No lease allows a tenant to destroy the property, whether it's them or their guests or their medical devices.
Without notice and without payment, just what we can do in this case?
We certainly can evict, and this is a common question that we get. Can we still file an eviction if they owe rent? No. Once you have possession, eviction is not possible. So the next question is, can I sue them? Absolutely. We love lawsuits in the United States. But is it a good idea to sue them? I don't know. What I do know is you as a landlord have a duty to mitigate your damage. And what this means is even if they didn't pay rent and they left, you still have to act in a way to find a replacement tenant as quickly as possible. And there are certain situations where a tenant leaves in the middle of the night. For example, they paid October, but now November 1st is here, and they're like, I'm just gonna go. And they pack up and they leave on November 1st. They don't tell you, and they still got months left on their lease. And it just turns out that on November 3rd, the best tenant on the planet walks up to you and says, I would like to lease your property. And you say, you're the best tenant on the planet, of course. And so you sign a lease, and boom, 3 days later, you've got somebody in there. You've just mitigated your damages. Yeah. That tenant only owes you 3 days because that's all you technically lost. And so you can deduct that from the security deposit. Guess what? Unless they damage the property, and you can deduct anybody, let's assume they didn't, you owe them a refund. Believe it or not, they don't just automatically waive their security deposit. Now the truth is, it is not common for the best tenant on the planet to show up 2 days later. But if it does, and you can calculate your damages less than that of the security deposit, you actually do owe a refund to that tenant. If your damage is exceeded, then you have to make a calculated decision. Do I go after them, or do I just take this as an expensive lesson learned?
To like somehow freeze the mortgage payment, I don't know, because if the house, like,
So there's no automatic mechanism to do that. You can maybe discuss this with your bank or mortgage company. More often than not, they're going to reject that request. They have no obligation to you based on what your work is like, you know, what the economy is like, what, you know, I mean, even during the pandemic, banks had to get their arms twisted before they gave any kind of relief to their clients, right? And so, yeah, they're under no obligation otherwise. And so don't just expect it, which is why you take a sufficient enough security deposit. It's why you inspect and you're on top of this as quickly as possible. And as soon as they're out, you're in there cleaning it out, beautifying it, putting it on the market and getting a new tenant in there.
How long does it take to evict a tenant? From what you said between 45 and 90. That was like what I was able to.
The average is 30 to 45 days.
30 to 45.
The majority of evictions start and stop in the eviction court, the very first one, the justice court. Most people, when they get a notice to vacate, I don't know about most people, but many people, when they get the notice alone does it, in many, many cases. For those who don't, they require the eviction to be filed. And in many of those cases, before trial, they're gone. For the vast majority of them, about 80% of them, once you win that judgment, you might have to purchase a writ of execution, which we call a writ of possession. But for the most part, within 45 days, they're gone.
Okay, so
Most of them.
bankruptcy. How do you handle it from there? That is. I want to put the second question.
Typically, they're going to file for bankruptcy before the foreclosure because the bankruptcy would actually stop the foreclosure. If for whatever reason they file for bankruptcy after the foreclosure, then the eviction cannot move forward, but you can request a lift of the stay. It does take an additional amount of time. You're probably going to want to talk to a bankruptcy attorney to get into the bankruptcy court to request the lift of stay so that you can get possession. Unfortunately, that would add additional time.
You now got to know that there was actually a false lien, maybe like 100, 250 grand. What do you do at that point?
Well, first off, you did know. What the law says is that the moment that a lien is filed, the world is on notice. Whether you were looking or not is a different story. And the fact that you take property subject to a superior lien to yours, you just didn't do a good title search. And so many times we have people who come in and say, I went in, I renovated the whole thing. I have a tenant there, and now I'm getting a foreclosure notice from something I didn't know existed. Well, unfortunately, if you buy it subject to somebody else's lien, you're stuck with it. Now, if yours was a superior lien, it washes all the inferior liens out, but not the other way around. If yours was a secondary lien, you take it subject to that mortgage, and you're going to have to find some way to resolve things with them. It's usually complicated and not always possible.
Send a letter, certified mail, waited 15 days, and then released it to us. Is that going to be okay?
If the title company released it to you and you were fully entitled to it, yeah, that's a pretty good day. That's a pretty good day.
Okay.
I don't know why they did it, especially if the other person didn't sign off. And what liability do they have when the buyer was in breach? Probably none. But yeah, you don't have to do anything beyond that.
Something that's not written, so it's like verbal. The neighbor said the listing agent, but there's no proof.
You can't accuse somebody of non-disclosure because the disclosures say that you have personal knowledge of. If he didn't know, he didn't know. It's possible he's an investor, he bought it without ever going to the property. As far as he knows, there's no issue with floods. What little research I've done, I don't know personally. The buyer then has their own duty to go and do their own research on the area for the things that are recorded that simply don't exist in the seller's personal knowledge. That's what inspections are for. That's what appraisals are for. That's what some digging around is for. So it's a little trickier there because I don't know that the seller absolutely knew. And if they disclosed only what they knew, then they didn't misrepresent.
Okay, so what's the best way to get the earnest money back?
In that scenario, it could be that the parties just decide to split it. and just say, look, there's a gray area. Is it worth going to court? Is it worth fighting over? Maybe, maybe not. But if it is, then go have the fight and let the judge make that determination. If it's not, then maybe offer a split. Understand that, hey, sometimes things just go awry, and it's good that you were able to get out and they didn't demand specific performance.
Is there a problem? Can the owner be like, you can't be subleasing rooms?
If the lease is silent on it, there's not anything you can really say. If the lease says this can only be used as a residence for this person or these people, that is a limitation, right? So now you have unauthorized occupants. It doesn't matter that he's subleasing, doesn't matter that he's just, using it as a boarding house and letting people stay there for free. What matters is whether or not the lease allows occupants that have not otherwise been disclosed. That's a violation. That should be met with notice of default, and if it's not cured, it should be met with notice to vacate. Next row. Yes, ma'am.
Okay, is there like a limit in Texas for emotional support beds?
The legislation on emotional support animals is extremely lacking. Right now, what we do know is that it's a misdemeanor to fake your emotional support animal. If you use what you claim to be an emotional support animal, and you know for sure is not, in an effort to defraud somebody, that's actually a crime.
On the application, he said, it says pets, he said it's not a pet, so it wasn't disclosed. Do they have to disclose it before they move in?
Nope. Because it's not a pet. If it is in fact an emotional support animal, it's not a pet. It is a medical device, and you got to stop seeing it as a pet.
Okay.
Think of it like a nebulizer. Think of it like a CPAP machine. Think of it like a bottle of pills. It is not a pet. It is a medical device. I encourage people to ask about animals, not pets. But if you've got a bad document, you got a bad document. So that's why the black and white always matters.
Provide some kind of paperwork for that animal and then make it real clear to the owner of the property.
So typically, when somebody's talking about animals, particularly in the application process, you ask about all of the animals, not pets. You ask about animals, you ask about shot records, you ask about insurance, you ask about bike history, you ask about all of those things, so that if it turns out a misrepresentation was made, then you can go back and say, aha, sorry, you misrepresented what this animal was or how this animal was supposed to be used. But if they mistakenly, and it's always it's just a mistake, forget to mention, or they suddenly develop the need for an emotional support animal, that can't be held against them.
So then they have to bring doctor's records to prove.
Not records, just
A letter.
a letter usually that establishes their medical need and that this animal satisfies that need.
Well, can a bird be an emotional support? A bird?
An armadillo could.
Trying to apply with versus like ESA would be a doctor's letter?
No.
Or they just say I have a service animal and that's it?
If it's not open and obvious, you can ask for one and two. Proof of the medical need, proof that the animal satisfies that need. A lot of times, both are present in the same letter. Again, if it's not open and obvious, you can ask for that. If it is obvious, then don't ask, because there's no need to ask. It becomes unreasonable at that point. And again, the certification thing is not a real thing in most cases because it just doesn't exist. There's no universal certification.
Well, they say for service, they have to have a certain type of training or versus ESA is more like psychological.
It depends on the service that the animal provides. But let's not get bogged down with semantics, because an emotional support animal is a service animal. It provides a different service, but it doesn't require any training whatsoever.
Yes.
Just its existence satisfies the need in many, many cases.
You had mentioned that you cannot ask them on the application if they have a emotional service animal?
No, what I said is, I don't recommend asking about pets.
Okay.
I recommend asking, do you have any animals?
Okay.
Because that would include service animals, right? And so you are allowed to ask. Now, if they say, you're not allowed to ask about that. Yeah, you can. There's nothing against the law in asking about the animals they have. They can explain that this particular animal is an emotional support animal, or a CNI dog, or some other kind of animal. Yes.
Can you ask for rabies vaccination?
Absolutely.
Okay.
Yes. You can ask for shot records. You can ask for bike history.
Your insurance does not cover that or allow that and wants to cancel you because they brought an animal on the property.
You better be able to prove that. You better be able to prove that your insurance will definitely cancel you, and make sure that that insurance is following the law themselves. Because more and more insurances are not allowed to make generic exclusions like that. And so if your insurance does it, get it from them in writing and then present that to the tenant and say, look, it's unreasonable for me to change my insurance. And so because they've told me this, I'm going to deny your request. But make sure you can prove it, because it can come up, and you don't want to get hit with a discrimination claim.
Okay. There, can you demand that tenant fill out a lease application and put a deposit in?
That depends on whether or not they've already got an active lease with the prior owner. If the prior owner and they have an active lease, when you purchase that property, you purchase that lease.
Okay.
And so to make them go through the process again wouldn't be appropriate until that lease has terminated. And so if it's got a hard end date, after that point, you can make them go through the application process again.
Have a deposit with that seller. That maybe that seller did not disclose that fact or something like that, I don't know.
Well, if you're not asking about deposits, that's another way where we're losing money, is because you always ask about the deposit, and rarely, and because I do this all the time, and I say, well, what's the status of the deposit? They never paid a deposit. Is it that they never paid a deposit to you, or they never paid a deposit, or well, I didn't get a deposit? That's not the question.
Yeah.
If they paid a deposit, guess who owes them their deposit back? You do.
If owner of income property for sale is in litigation with occupying tenants.
That's going to depend on how well things are filed. You're going to have to do some research to find active litigation. There are documents that sometimes put a lien on property. It's called a lis pendens. We often do that when we're in the middle of litigation, when we're arguing over title. We'll place a lis pendens on a property that puts the whole world on notice. Hey, if you want to buy this place, it's subject to the claim that we're fighting over in the courts. And so if you haven't done a proper search for things like lis pendens, or you haven't done a proper search in the eviction courts to see if something is pending there, then you're just kind of dropping the ball in that respect. But all that's public record.
The appeal do not show the appeal hearing, but does the Laren do that? Not very clear.
When someone no-shows, you're going to win that by default. But sometimes they don't show up because they're packing up and they're leaving anyway, and which is a good thing for you. But I always recommend following the case up to the appeal and getting that judgment, because too many landlords mistakenly believe that if a tenant files an appeal and then leaves before that appeal judgment, well, they can always rely on the judgment they earn from the justice of the peace. But that's just not true. The moment that tenant files that appeal, that justice of the peace judgment is gone. It no longer exists. To get a judgment that will stick, you're going to have to go to the county court and secure a new judgment in front of a new judge. Unless you do that, so many times what ends up happening is the landlords just let that case dismiss on its own, and that eviction goes away. And guess what? When a subsequent landlord looks, they're going to see 0 evictions for that tenant because you didn't follow through. Unless there's an actual eviction judgment, it does not get recorded. Now, could someone go and dig and go through court records and see was something filed and something appealed, even if it was dismissed later? Yeah, I mean, you can do that, but the average check doesn't find things that were just filed. It only looks for final judgments. And again, once that appeal is in place, that judgment is gone, and unless you follow it up to the county court and get that judgment, there's going to be no eviction to speak of.
If tenant changes their mind about moving in, can I legally keep the deposit, or should it be returned?
It depends. I don't know what your lease says. Take a look at what your lease says. It also depends on the reason that they're leaving. If they're leaving because your house caught on fire, no, you can't keep anything. Your house caught on fire. If they're leaving just because they changed their mind, then it's going to depend on a number of facts. The property code says if they find a replacement tenant for you, you don't get to keep their money. If you find a replacement tenant and you've suffered no damages, we talked about this earlier, where you've mitigated your own damages, no, you can't keep their money automatically. Now, if in the process to mitigate your damages, you expend money and that exceeds the money they paid, absolutely, you can keep it under those facts, but it's really going to depend on what happens. My recommendation is never to go halvesies. Never, ever, 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 because stuff goes wrong. Don't give keys, don't sign leases, don't accept partial money. Only go 100% or don't do it at all. Take 100% of the first month's rent, 100% of the deposit in exchange for keys and a signed lease. You say, well, but they wanted me to hold it for a month. Well, then add that month to the lease. You're losing money otherwise. Now, if you want to give it for free, that's fine. But go ahead and take the money, waive 1 month of rent, give them the keys, and let them take possession of it. Because here's just a practical thing. For your insurance, you might lose coverage if your house stays vacant for more than 30 days. Why would you put yourself in that situation? That's dangerous for you. You don't want to be there. What you want instead is someone in place and someone who is paying for the time that they're there. And if they want an extra month, they should pay for an extra month. Or maybe a half portion. Maybe they're going to pay a prorated amount for that empty month, but it's on them. They've paid it and you've accepted those terms. The half and half only leads to problems. That's all I've ever seen from it.
Used to pay rent illegal. I had previously heard that post-dated checks are not legal in any case.
Post-dated checks are 1000% legal. Why you would take them, I don't know. It's just not a good idea. You're subject to all sorts of NSF fees and complications. Additionally, you might be in a position where the tenant claims, no, I paid the rent, you did something wrong with it. You lost it, you failed to deposit it on time or something. I wouldn't take post-dated checks. If someone wants to pay in advance, that's another thing. It's got its own issues that I would address, but I wouldn't take post-dated checks as a method of payment. If anything, what I would do is I would create a portal system where they can pay you electronically, or I would get them and put the onus on that tenant to deliver that check to me ahead of schedule so that the funds come to me before the rent is due. Otherwise, it's late and subject to late fees.
Is it legal for me to have a holding fee and once lease is signed, transfer it to their deposit?
Oh, I see. Yeah, I see this a lot too. Yeah, it's perfectly legal. I don't know how wise it is because, again, they're preventing you from using your money. You're not actually getting anything if you're going to simply deposit this holding fee as their security deposit. They're essentially scamming you out of a month of rent. It's not something that I ever recommend. I don't see it as a good option. In fact, what I tend to recommend is if your applicant doesn't have 100% of the money when they're signing the lease and they're not ready to sign the lease now, then that's not an applicant you have to accept. You can pass them up and go to the next qualified applicant who meets your criteria, who has the money, and can take possession now. Otherwise, you're just giving away money. You may as well take a stack of hundreds, put it in a bucket, and set it on fire, because that's effectively what you're doing.
Started from the beginning, or what will be with the debt? Or can water company demand this money from the landlord?
So if the utility is in the name of the tenant, that's the tenant's bill.
Yes.
Can the landlord be held liable for this? They shouldn't be held liable for it because it's not their contract.
Yes.
The problem is water can't be given away. And so the money is owed. And technically these water utility companies have a lien on the property for unpaid water. And so if the water company says something to that effect, instead of wrestling with a lien, I would just pay it. It's an unfortunate thing, but technically that's the tenant's debt, but if it causes harm to the owner's property, it's not worth fighting with them over this. They have statutory liens that are protected by state law, and you don't want a foreclosure based on a few $100s worth of a lien.
What it says, the 3-day notice to vacate includes or excludes a weekend?
So, a couple of things. Once the notice is delivered, the date of delivery is day 0. So it's important never to include that day. That's day 0, it doesn't count, it's not part of the equation. The next 3 days are counted, and it does include weekends and holidays. The following day, the fourth day, however, if the fourth day, your first day to file, is a weekend or a holiday, you can't file with the court because the court's not open, so you have to wait till the first business day thereafter to file. So weekends and holidays do come into play if the fourth day is on a weekend or a holiday. So yes and no. Let's say I deliver a notice to vacate on Wednesday. So Wednesday doesn't count, Wednesday's day 0. Thursday, Friday, Saturday. Can I evict on Sunday? I mean, the code says I can, but there aren't any courts open on Sunday, so I can't. Let's say instead that I delivered the notice to vacate on Friday. Friday does not count, but Saturday, Sunday, and Monday do. I can file on Tuesday as long as it's not a holiday.
Okay, and the delivery could also be the day that you bring the certified letter to the...
The mailbox rule says yes. A lot of judges say no. And so it's going to depend on where the judge stands. What we do is we send all of our notices by regular and certified mail. And the reason we do both is because certified mail has tracking, and regular mail cannot be rejected. And now you might say, well, they could mark it return to sender and never open it. Well, it's true, but the moment they touch it and put return to sender, they've gotten it, right? They can't mark it return to sender unless they've received it. So the fact that they don't know when to open it or read it, that doesn't matter. The only thing that matters is that I delivered it. And so we send it regular and certified. We send them together. We have proof because we have our stamps.com receipt that shows the day we mailed it and put it in the mail. We track it to the day that it is delivered or attempted delivered. Because we know that on the day that the letter carrier takes both letters in their bag and they, I'm looking for Joe Tenant. No Joe Tenant? Well, let me leave the regular one here, and I'm gonna leave a little note for Joe Tenant to come to the post office, and I'm gonna mark it in my little keypad, attempted delivery on this date. That's our day 0. We count 1, 2, 3 thereafter, and we file on the 4th. Every time.
Attack known animal trying to be used in
Anybody
ESA.
else?
If you have knowledge that the animal has bitten somebody, then it would be unreasonable for them to use that, even if they have a letter from a licensed medical provider. You could say at that point, that's not a reasonable request, and it is reasonable for me to deny your request.
Oh, and if it's a known breed, you have no documentation that it's attacked, but like a Rottweiler, etc.
The law is getting tougher on that issue. It used to be that you could make that excuse, but courts are not upholding that. There's no such thing as a known dangerous breed of animal. It has to be specific to that animal. Because there are Rottweilers that are perfectly gentle. Well-trained, well-kept, not bred for violence. Unfortunately, there are others that, but that's true of any dog. You can get a violent Chihuahua who's gonna cause injury to somebody, even though they're small, right? But then you can get a German Shepherd who could tear you to shreds, but could be as gentle as a lamb. Now, for those of you who are just starting out or maybe just don't have a whole lot of experience with the eviction process, I have an offer for you that we are making available to all of our clients, particularly for those in Texas. If you have rental property in the state of Texas and are issuing notices or would like to learn a better way to issue notices and file evictions and even handle eviction appeals in the state of Texas, then you may want to check out our eviction course. There's a link in the description below, but you can also check out attorneyeg.com/EV for more information on that eviction course. We walk you through the process of your notices, of filing, and even the kinds of things that you can expect at trial and on appeal. If you would like a course where we go step by step from notice to judgment to help you recover your property faster, I strongly encourage you to check out attorneyeg.com/EV, our Texas eviction course from start to finish. Again, I'm going to walk you through multiple multiple modules. I give you samples of your notices, samples of an eviction petition, and plenty of resources along with my step-by-step training to help you file your own eviction with success. If you need more information, feel free to send us an email at info@attorneyeg.com and check us out at attorneyeg.com/EV for information on our Texas eviction course.